Okay, let's go ahead and go on the record on cause number DC 2016477. Council, make your appearance.
My name is Ronnie Atten for the plaintiff Fivehold Collective.
Okay, go ahead and proceed.
Thank you, Your Honor. Fivehold has filed this interpleader petition, really just asking the court to order lawyer's title to deposit the earnest money funds in dispute into the court's registry, so that upon any final disposition of this case, the money will be able to be dispersed quickly. The defendant has not, as I said, responded at any point to any sort of communications, negotiations, pleadings, at all. And lawyer's title has represented to myself that they will not do anything with the money other than deposit into the court's registry.
So they're not opposed to depositing it?
No, sir. No, they've actually asked us to file this interpleader.
Okay. All right, the court will grant the interpleader action. I assume that the defendant, the Korean church, was put on notice?
Yes, sir.
And did you file an order with this?
I do not believe that I've yet filed. Actually, yes, I think we did file a proposed order.
Let me see.
If not, I can get one filed this afternoon.
I don't, maybe that's it. Let's see. Guillermo, can you go pick up the order? All right, I'll go ahead and sign it. And let me just check something real quick. Just FYI, this is set on a dismissal docket for 6/28. I imagine we're going to eventually need to set this for trial. Has the defendant, Seoul Korean Baptist Church, have they been served?
Their attorney accepted service, and we've got a waiver on file.
Waiver of service, okay.
Yes.
Has he filed an answer?
No, Your Honor.
Okay. Okay. All righty. Yeah, so what needs to happen on this? I guess we need to set it for trial?
Yes, sir, and we intend to move for default if the defendant continues to be unresponsive.
Okay. Right, for now, I guess, should it stay on a dismissal docket? Should it go onto a trial docket? I guess your position is when the waiver of service doesn't constitute an answer, I guess?
Correct.
Okay. All right, it's on the DWAP docket for 6/28. It's up to you if you want to try to move for default or how you want to do that. But make sure that when you do, you send a copy of the default to the attorney for the other side.
Yes, Your Honor. Thank you.
Okay. All right. Thank you so much.
Thank you. May I be excused?
You may.
Thank you.
Mr. Habata, what are you here for? Mr. Habata, are you there?
Yeah, sorry, Judge. Hold on. I expect for you to. I'm here for to respond to a motion to continue our summary judgment hearing.
Okay.
7:00, Judge. I'm a little bit early. Just want to make sure I got in.
I wasn't sure if you were involved with this 145 hearing. So, okay. Let's go ahead and get started on the motion to appoint receiver. let's go on the record on cause number DC 191235, John Coyle versus East Bay Inc. Council, make your appearances.
Michael Donahue with Freeman and Feiger here on behalf of plaintiffs and movants.
Frank Cram, Your Honor, on behalf of defendant John K. Coyle, AVE Inc. and East Bay Inc.
Okay, let's go ahead and proceed.
Right, Your Honor, Michael Donahue here on behalf of movant John A. Coyle. Mr. Coyle is moving for an appointment of a receiver. As the court's aware, we had a trial back in mid-March of this case. The court entered final judgment on April the 6th of this year in favor of the plaintiff, John Altair Coyle, as well as both individually and derivatively on behalf of East Bay and AVE Inc., declaring that John Altair Coyle is the 100% owner of all shares of both East Bay Inc. and AVE Inc. That was in dispute, as well as voiding a warranty deed on 2600 Forest Lane here in Dallas, that John Kenneth Coyle had signed a warranty deed purportedly conveying that property on behalf of East Bay to a Bill Wilson, which the court found was a straw man. And Mr. Wilson in turn conveyed the property to AVE Inc., but the court voided the transaction to Mr. Wilson to where the property should remain in the ownership of East Bay Inc. And what's occurred, Your Honor, is that these properties that are owned by AVE and East Bay are adult retail stores. And there are many of the properties, there's 12 of them located in the Houston, Harris County area. I've attached to the motion, which is verified by John A. Coyle, a list of 12 of those properties, as well as the deeds, whereby John Kenneth Coyle would transfer those properties, again, were either in the name of AVE Inc. or East Bay Inc. And what happened is during the pendency of this lawsuit, after we filed for our declaratory judgment action, John Kenneth Coyle either signing for himself or by himself, ostensibly on behalf of East Bay Inc., transferred the properties to Ken Inc., a company that he wholly owns and controls, or he would have his daughter sign on behalf of
I'm familiar with the lawsuit. Is anything, I already heard all this stuff. Is there anything that's happened since then, since the lawsuit occurred? Since I signed the judgment?
Not since the final judgment, but during the pendency of the lawsuit, these properties, primarily in Texas, but there's also properties in Nebraska, in Illinois, in Colorado, in Arkansas, that are also listed, that he's done the same thing with. They were in East Bay or AVE's name, and he transferred them to Ken Inc. last year, in July or October of last year, to transfer them out of those, to ostensibly transfer them out, and without the authority or the consent of John Altair Coyle.
Let me ask this. So I made a judgment in this case. When I did the judgment, when I rendered the judgment, how many stores were there as part of the judgment?
The judgment, Your Honor, only addresses the Forest Lane property. That's the only store that's addressed in the judgment as far as the voiding the deed to Bill Wilson.
Okay.
But as far as the ownership of those entities, the court awarded ownership of AVE as well as East Bay 100% to John Altair Coyle. He's the 100% shareholder and has been. And while this lawsuit was pending, his father, John Kenneth Coyle, transferred properties out of AVE Inc. and East Bay Inc., just like he did the Forest Lane property, and transferred them to a company he wholly controls, Ken Inc.
Okay.
And that's what's occurred. And we're asking for a receivership, not just over the Forest Lane property, Your Honor, which is addressed in your final judgment, but all the other properties that were owned by AVE and East Bay Inc., which he, in an unauthorized manner, transferred out of to a company he owns and controls, to Ken Inc.
Okay, response?
Your Honor, the very first three properties listed on his exhibit, the first two occurred prior to this lawsuit ever being filed. And the first three appear to be to entities that there's certainly been no evidence that my client, John K. Coyle, has any ownership interest in those three entities. So the assumption would be those are arm's length transactions for which East Bay received and AVE Inc. received consideration, fair value consideration. The remaining transactions, Your Honor, although during the pendency of the lawsuit, there's been nothing to show that AVE or East Bay didn't receive fair value consideration, and they certainly were never part of this lawsuit. So, you know, the order he has submitted to the court has the receiver taking control of three properties, which by all evidence before the court were to third parties who paid fair value. The remaining ones to Kin Inc., somebody's got to make a determination. I would assume a court through a trial of whether or not East Bay and AVE received fair value consideration. But when they were transferred to Kin Inc., absent that, you know, he's asking that the receiver take possession and control of properties for which there's been absolutely no evidence that at the time the deed was executed, you know, the entity didn't receive what they were supposed to. And absent that, how can he take control of those properties?
So just so it's clear, we have Mr. Trey Black here, who I'd mentioned to you guys is who I was thinking would be a good receiver for this case, given there's going to be a lot of logistics here. And Mr. Black, do you have an attorney here with you? Is Mr. Farmer here with you as your attorney?
Yes, he was having some issues.
Oh, he's here.
Okay, yeah, he should be here. There's
here.
Mr. Farmer. Okay.
So I just want to make sure I'm looking at the judgment right now, and this is going to get a little bit tricky. So this case, Mr. Black, involves a number of different, involved the ownership of two entities. There was the East Coyle, I believe, entity, is that right? And the
East
AVE
Bay.
entity.
East Bay, Your Honor, East Bay Inc.
East Bay
AVE.
Inc., I'm sorry, and
That's right.
the AVE company, so two different entities. The court has established, there was, as part of this, also there was a transaction involving I don't know if you've ever seen it, it's up on Forest Lane, what is the name of that store? Eros Zone or Errata Zone, or what's the
Zone
name?
d'Erotica. Zone d'Erotica, I believe it is.
Zone d'Erotica, I'm sorry, Zone d'Erotica store. The court has already made a determination that that was owned by one of these two entities. There is, and that the owner of these two entities was the younger Coyle.
John Altair Coyle.
John A. Coyle. And so you're going to need to take a look at this if you decide you want to take this, is obviously transferring ownership of this. It sounds like there may be an issue as well, though we didn't really litigate this, of what exactly does this entity own, these two entities own. And so you would probably need counsel to bring suit if there was fraudulent transfers, which is obviously a serious concern in this case. I'm not telling you how to do your job, but I'm just telling you what the issues may be. And so, you know, you would definitely, there's going to be a lot of logistics issues in making sure that these stores run and that you collect all of the proceeds from the stores and then make sure they're properly distributed, but also potentially bringing suit to determine what exactly is owned by these entities, which stores are owned and which ones aren't. Does that make sense, Mr. Black or Mr. Farmer?
It does, Judge.
Yes, sir.
Okay. Mr. Donahue, do you have a proposed order on this?
I do, Your Honor. I submitted one. He filed it this morning. It's got attached to it as an exhibit all the properties which we contend were owned by AVE or East Bay that were transferred out of those two entities.
And that's my concern, Your Honor. It orders the receiver to take possession of those properties when, they weren't even part of the lawsuit.
Well, we were determining in this lawsuit who owned these two entities. The court has determined that these two entities are owned by John A. Coyle. And so, if these entities own these stores, then they would be part of the receivership.
Well, I think that's the issue, Your Honor. They clearly do not, by the plaintiff's own exhibit, they don't own these properties. And yet they're listed as properties he's going to take control of.
Your Honor, what the contention is that these properties were transferred out of AVE and East Bay to Ken Inc. During the pendency of this lawsuit without authority. That was transferred by John Kenneth to his company, the Ken Inc. And again, without the authority of AVE or East Bay, and without the knowledge or consent of John A. Coyle.
And I think go ahead, Your Honor.
Mr. Farmer, just so you kind of, Mr. Black, so there's going to be an issue here there's potentially going to be an issue here about who owns these stores. And did one of the allegations, and there's a very extensive findings of facts, conclusions of law that will give you a good background, Mr. Farmer, Mr. Black, on what exactly I ruled on, because it's very detailed within the findings of fact, conclusions of law, on what exactly I ruled on. But one of the allegations that I found credible and ruled on was that there was a history of John K. Coyle, the father. So there's father and son. John K. Coyle did have a tendency to try to transfer things that he didn't own. And there's a long tortured history about why that happened. But so one of the issues in this case would be, in your receivership is, if he did transfer it, did he have the authority to transfer it? And what is the legal effect of that? And so what I think makes the most sense, since I haven't seen the receivership order, and I'm open to suggestions on how you want to handle this, Mr. Donahue, is that this is how I generally do it, is have a meeting where you and Mr. Farmer, Mr. Black, and of course, Mr. Cram, kind of sit down and try to craft the parameters of this order, because I think in this case in particular, it's going to be a little bit confusing on what, how this should be crafted. Does that make sense? So, because there's going to be usually, let's say this was, hypothetically Walmart. Walmart probably knows which stores are its and which stores are not. In this case, as a receiver, you're going to have to attempt to take these over. And then if there's resistance from the other putative owners, you may have to file suit to litigate these issues. Does that make sense?
It does.
Yeah, it does.
What would be your preferred way to handle this, Mr. Farmer, Mr. Black, in terms of, scheduling of this? Do you want to, what we've done before, I think, is maybe set up a hearing in, 3 or 4 days, or preferably probably next Monday, so you have a chance to try to hash out the terms of the order. If you think you can do it really quickly, we could try to do it in the next 30 minutes. I just think it might be better if you took a close look at it, got a little deeper into the file. I don't know, Mr. Farmer, have you had a chance to read any of the file yet?
No, Your Honor. And
Okay.
I do believe having a dedicated meeting after reviewing the file would be very fruitful.
So why don't we do this? I'm going to order you guys to all confer. How many days, or do you think you could what's a good day for you, Mr. Farmer, Mr. Black, how much time do you need before you have, what I'm envisioning is that you have a meeting with the four of you and then you have a hearing with me after that. So how many days before you have the meeting with the four of you, before you meet with me, how many days would you need that, Mr. Farmer?
Judge, I think we could have the meeting within 1 week,
Okay.
if the court permits that.
Could you maybe do one option? This is, one option would be maybe you meet with them on Friday and then have
Yes,
the
sir.
hearing on Monday. Would that give
Yes,
you
sir.
enough time?
Yes, sir. In the interim, Your Honor, is there any way to do some type of inventory prior to that, prior to those meetings
An inventory of,
of the property at the locations we speak about, just to make sure that we know what's there currently?
yeah, I think you probably want to, I don't know. It's up to y'all. You might want to do that after the receivership order, but I don't really care the order of it.
Okay.
Mr.
Okay.
Cram, Mr. Donahue, how do you feel about, because some of the store here would be easy to do, but you also have all these stores in Houston and all around the country. So
Okay.
I don't know that you could visit those.
Right.
It's my thought, but I'm flexible. Mr. Donahue, Mr. Cram, how does the meeting with them on Friday and then doing a hearing on Monday, does that fit in y'all's schedule?
This is Mr. Donahue. It would be okay, Your Honor. I've got a minor surgery on Wednesday morning, but I should be up and about, I would think, Thursday afternoon. So Friday should work for me. I may not look too good, but I'll be able to do that. Yeah.
Mr. Cram, what about you?
Friday afternoon is fine, Your Honor. I've got a couple of closings Friday morning, but Friday afternoon would be great.
Friday afternoon work for everyone?
I believe so.
Yes, sir.
Yes.
And so has there been an impediment right now for Mr. John A. Coyle being able to get into the stores?
Your Honor, he's talked with his father, but as far as Mr. Farmer suggested an inventory, he doesn't, John A. Coyle does not have access to the stores, has not been given access, if you will, to inventory what's there. So that would be something that would have to be forthcoming from John K. if that's going to be done.
And I would
anytime
imagine
soon.
it's something we can work out Friday afternoon.
And one thing I want to make 100% clear, because I see Mr. John K. Coyle is on the line, is if there is any effort to try to restrict the receiver or his representatives from accessing any of these stores or inventorying any of these stores, it will be met with great displeasure by the court. I want to make that 100% clear. You need to cooperate with the receiver. As much as you may not want to, you need to cooperate. So if they need to access documents or records or inventory or whatever, you guys need to cooperate with that. Mr. Coyle, do you understand that? Mr. Coyle, you're muted. Mr. Coyle, you're still muted.
I don't know if he's still there. Oh, there he is.
He's there. He's just muted. Mr. Coyle, you need to unmute.
There you go. I don't know.
Mr. Coyle, he's talking, but I can't hear him.
I think it relies on his daughter to kind of do all the technical stuff, and she must not be right there. While he's trying to figure that out, Your Honor, one thing, we were in the process of filing a notice of appeal. What I've asked the court to do in my response is if the court could set a supersedious bond, that if we are able to post that, that will suspend the necessity for the receiver.
You'd probably want to set a hearing on that because this case is kind of complicated because we don't know exactly what the value is, but it would be probably in the millions of dollars is my guess.
Okay, can I get that on the docket for Monday at the same time we hear this?
Mr. Donahue, I haven't seen your response, so does it
It
move
was
further?
a pretty bare bones motion. I'll say that, Mr. Cram. I'm not real sure what it is you're seeking. In fact, it almost looked like you asked the plaintiffs to my client to post a supersedious.
That may have been an error on my part.
Okay.
I'll amend my motion, Your Honor, and try to get it
Why
set.
don't we do this? Why don't you amend it and then contact my clerks about setting it? But I am,
Yes, sir.
I want to make sure Mr. Donahue has a chance to respond. And so,
Yes.
so you need to get that on file, but you would be, you're going to be required to post the bond on this case, not Mr. Donahue's client. So
Yes, I understand, Your Honor.
Thank you, Frank.
what time do you want to have your hearing on Monday for the receivership?
I'm wide open, Your Honor.
And I'm open also, Your Honor.
Mr. Black, Mr. Farmer? Does Monday work for you?
Judge, I am too. I sure would like something that is after 10 a.m. I'm in good shape.
Why don't we
Judge,
do-
1 p.m. Oh, okay. I'm sorry.
So go ahead, Mr. Farmer.
I was going to say, I was going to suggest afternoon, 1 p.m. Or after, but I'll try to make whatever work.
Let's do 3 o'clock then.
Okay.
And Mr. Black, I think it would be helpful for everyone to hear kind of a little bit about your background and because of why I feel that you'd be such a good receiver with your logistics background.
Sure. Your Honor, I've been appointed receiver for over 40 times over the last 8 or 9 years throughout the state of Texas. We traditionally have been able to save the court and parties resources, money by utilizing some of the support service teams that we would use. One is an entity called On Target Supplies and Logistics. It's a associated entity that has the labor, the trucks, the warehousing, asset tagging, safety and security components necessary in order to execute these types of receiverships. If there is a need for sale of real estate, then I do have my real estate license with Briggs Freeman that they ordinarily come in to help with liquidation of any kind of real estate. So, from inventory management, we do have an asset cloud system to kind of help with inventory management. So not only the court can see inventory, but also the different parties. And so I think that the logistics function has been solid, has been a really good component of these receiverships over the years, and also helps reduce costs since it's all under one roof.
Okay. Any questions for Mr. Black?
No, for Your Honor, and just to clarify, this receivership order will not be for liquidation of any of the assets.
Mr. Donahue, I didn't anticipate there'd be a liquidation. Is that what you're asking for?
There's nothing that specifically talks about liquidating anything, but at the same time, I mean, that may fall within what the receiver may need to do. I don't know. I think the receivership proposed order probably is broad enough to permit that, but there's nothing that's directly on point as far as liquidating existing assets.
And Mr. Black, I think you've been involved in some receiverships in my court, or maybe not, where there's a wind down receiver. This is not a wind down receivership, so this is taking over the receiver, the company, so that we can get a proper transfer of it to the plaintiff in this case. So
yeah, absolutely. Yeah, I mean we've done both.
So, and there may be situations where you make a determination, some of this land may be kind of valuable. I don't know where some of these properties are, and you may make a determination that, store number 7 in Houston really isn't functioning. It'd be a lot better to sell it. And you'd be able to make more money for the plaintiff or for the company. You just need to make those types of determinations. I don't know. And there's going to be obviously some litigation possibly over who exactly owns these stores. But Mr. Farmer, I urge you to look carefully at the history involving Mr. John K. Coyle and some of the things that have happened in the past with him involving fraudulent documents and things like that. I'd be, just make sure you're not taking everything at face value,
Yes, sir.
if that makes sense.
Yes, sir.
Mr. Quall, I think you've been unmuted now. Do you understand that you're not to attempt to disrupt the activities of the receiver?
Anybody can go into any store they want. I'm not going to keep anybody out of a store. They
Okay,
want to come visit with me.
and records and books as well. Okay. All right, we will see you guys back here next Monday at 3. Mr. Black, if there's any serious issues you need my help with, reach out to my coordinator, Rhonda. If there needs to be an emergency hearing before then, I don't anticipate that. Otherwise, we'll see you next Monday at 3. Oh, and where did you guys want to meet, or how did you want to meet beforehand on Friday?
I'm not opposed to a virtual meeting. If that's okay.
That's fine with me, Your Honor.
Mr. Donahue,
That works for me if that's that's what's best. Sure.
Mr. Black.
That's fine for me as well, Judge.
Okay. All right. What time did you guys want to meet, and who wants to set up the Zoom or whatever you're going to use?
Judge, my office will reach out to counsel in coordination with Mr. Farmer to get everyone on the call.
Perfect. All right. We will see you guys next Monday at 3. Good luck with that, and I appreciate your service, Mr. Black.
Very good. Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
Okay. The next hearing, I believe some of you guys are here, if not all of you. Okay, the Compass Data Centers versus Trout. Anyone here on that case?
Yes, Your Honor. Sean Lemoyne on behalf of Compass Data Centers.
Okay, anyone here for the other side?
Yeah, Mr. Hamad is here, but I think he's on mute.
Mr. Amati, you need to unmute,
Oh,
sir.
My goodness, sorry. Yes, so I'm here for defendant Mohammed Fotu, Your Honor, opposing the motion.
Okay. Let's go ahead and get started. Mr. Wright, is he on that case as well?
No, Your Honor, I am not.
Okay, so just Mr. Lemoyne and Mr. Hamada.
Yes, Your Honor.
Yes, Your Honor.
All right, let's go ahead and proceed. Let's go on the record on cause number DC 2011957, Compass Data Centers versus Trout. Counsel, make your appearances.
Your Honor, Sean Lemoyne on behalf of Compass Data Centers, LLC, and EdgePoint Systems, LLC, and Radix IoT, LLC.
Your Honor, Sean Hamada on behalf of the defendant Mohammed Fotu.
Okay. Let's proceed.
Your Honor, with your permission, I'm going to share my screen. I have a very short PowerPoint.
All right, very short because you have 15 minutes.
All right.
Okay, I see it. Mr. Lemoyne, you need to proceed. Mr. Lemoyne, are you there? Can you hear me, Mr. Amata?
Yes, I can, Your Honor.
Mr. Lemoyne, are you there? All right, technical issues. Not sure what happened. Mr. Lemoyne, are you still there? You're muted. No, he's here. He's on the bottom. I can see him. So now he's,
Judge, can you see me?
yeah, I can now.
Okay, not sure exactly what happened with that. So I will try this again. So here are the deadlines that are coming up. Mr. Fotu has filed a partial summary judgment motion. It only addresses one of multiple claims we have. We still have till December for expert discovery or for non-expert discovery, March 21, 2022 for expert discovery, and May 3rd, 2022 for the trial. So we have quite a bit of time between now and then to get there. There have been no depositions taken, although we have requested some, and Mr. Fatou has effectively blocked those. And so my hope is that we will get some resolution from this hearing that indicates to Mr. Fatou that he needs to sit for a deposition. The argument that is being advanced by Mr. Fatou is basically that this is one of your kind of typical anti-reliance summary judgment motions. The problem with that argument is that it's not. This is not a scenario where we are suing on a warranty that was specifically disclaimed in the actual agreement. And this was a multi-million-dollar transaction where Mr. Fatou got paid handsomely. And then our allegation is that once we got in and took over the company, we found out that there were misrepresentations, and not external misrepresentations, but misrepresentations that would actually fall under the reps and warranties clauses. And the reason that's important is because in our particular contract, we have specific carve-outs that say that the reps and warranties that are made in the agreements are actually true and not misleading. So whereas you would typically have a summary judgment motion where someone stands up and says, Judge, they claimed that we said X and the contract specifically disclaims X, our argument is the opposite of that. Our argument is that it's contained within the actual agreement. And there's a couple of examples of that, but here's one of them with regard to permits and licenses, where it says that the company has all of the permits and licenses needed to to make the business run. Our allegation being the company didn't have that, hence the suit against Mr. Fatou for fraud. And I think this does a pretty good job of crystallizing what Mr. Fatou's argument is and why he says, well, Judge Hoffman, you can run out and grant summary judgment right now. His argument is, I represent that you have all of the furniture for this business. In this instance, it would be the intellectual property. And then he says, well, I didn't mean chairs. I know I said furniture, but I didn't mean chairs. So you can't rely on the fact that there are no chairs in the building. And that's exactly the argument that he's making on the intellectual property clause. He represents that the company has all the intellectual property it needs, just like all the licenses. But intellectual property doesn't specify what particular chair we're talking about. And so that's what the debate comes down to. And so we need to, at a minimum, we need to be able to take his deposition. So he has to take a position and say, well, licenses doesn't really mean DG Lugs, because that's his argument. His argument is, well, the contract doesn't say the word DG Lugs, just like if the contract didn't say the word, I want a Herman Miller chair, it just says furniture, and therefore I should get a summary judgment because of anti-reliance provisions. Well, that's not how the contract reads. It's basically not the argument or what we signed up for. And so when we say we need to have discovery to depose him to get to our defense on the anti-reliance clause, I mean, that's a legitimate basis for us to take his deposition. By way, and I'll jump out of that now. Sorry, Judge. Just by way of a couple of arguments.
Mr. White, I get it. Let me hear from Mr. Muhammad.
Yes, Your Honor. First of all, the plaintiffs just haven't met any of the elements necessary to continue our summary judgment motion. Number one, they haven't been diligent in pursuing discovery. And I've got a PowerPoint as well, if you don't mind if I could share really quick, Your Honor.
Briefly.
I understand. We thought that this was set for half an hour, but first of all, Compass has had ample time for discovery. The case has been on file since August of 20. They only served 2 sets of requests for production 6 months after they filed the lawsuit. Fatou fully responded to those requests and produced documents over a month prior to filing his summary judgment. And Compass has had sole possession of Fatou's communications. All of these emails, everything for BitBox communications, that including all the pre-transaction communications since December 2017. And why is that important? Because as one of the cases we cited says, Your Honor, a trial court may presume a plaintiff has investigated its own case prior to filing the lawsuit. There's nothing more for FOTU to produce. And Judge, the issue of whether he's going to appear for a deposition is a red herring. The issue is we've served all this discovery, and it's the plaintiffs who haven't responded adequately. And in fact, we have a motion to compel set for a couple of weeks from now. We tried to set it for today, but we just couldn't get it set at the same time as this hearing. So what we are trying to prevent is, of course, being blindsided by the plaintiffs when they produce documents at the deposition that they haven't produced to us yet. We've stated numerous times that they have all the documents that FOTU would have had, and we don't have them anymore. In other words, we gave over all of the emails, control over the email communications, the account, to Compass. We don't have them anymore.
Why wouldn't he need a deposition, though, at the very least?
Well, Judge, this is why. Because it's not material. There's no testimony that's necessary when the very representations alleged to be fraudulent are disclaimed by the terms of a valid, enforceable arm's length agreement. Again, we cited the McFadden case for this. Additional discovery is a waste of time and expense if it will make no difference. That court cited the Texas Supreme Court case, National Union, where the court said it was error for the appellate court to require, who said that summary judgment was premature.
But isn't he saying that it is ambiguous, though?
Judge, that's not what they said in their petition. They said that it's a valid and enforceable agreement. And so we state that the sole issue in our summary judgment motion is whether these fraudulent inducement claims fail as a matter of law because the contribution agreement, and specifically these sections which plaintiffs included in their motion, negate the justifiable reliance element of each of Compass's fraud claims. I mean, there's numerous Texas Supreme Court cases right on point. A clause that's clearly and unequivocally expresses the party's intent to disclaim reliance on the specific misrepresentations at issue can preclude a fraudulent inducement claim as a matter of law. So here's the point. The contribution agreement is a fully integrated contract that contains all of FOTU's representations concerning BitBox and its technology. Article 6.02 and Section 6.02 and Article 2 of the agreement state that. None of the alleged false representations regarding Digilux, which is the technology at issue, that Compass complains of in its petition, in this motion, wherever, are contained anywhere in the contribution agreement. In fact, Digilux is nowhere mentioned in the contribution agreement at all. And FOTU contractually disclaimed all representations that are not made in the contribution agreement. Mr. Lemoyne wanted to highlight the part that says, except for the representations contained in this Article 2, but what we're pointing out is FOTU, who's an equity owner, if you see in red, disclaimed all other representations and warranties. And further, he stated that he disclaimed all liability and responsibility for any representation, warranty, projection, forecast, statement, or information made, communicated, or furnished orally or in writing to the contributor, which in this
Mr. Lemoyne, how do you respond to this?
With the furniture analogy, Judge, they represent that we have all the licenses, permits, et cetera, to run the business. We're not saying that, he's not saying that DG Lux was excluded from the agreement. He's trying to shoehorn in generic language that says other than the reps contained herein. But it's like if I said we get all of the furniture, and then he stands up and says, well, you didn't say a Herman Miller chair, so therefore it's not furniture. That's absurd. And Mr. Hamada's kind of proved his argument, my argument, which is he's claiming that we haven't produced discovery. We produced tens of thousands of documents. He won't let us depose Mr. FOTU, but he wants to move forward to prevent us from getting Mr. FOTU to say on the record that that a Herman Miller chair is furniture, because he doesn't want that to occur, and he wants you to grant summary judgment before we can get that deposition of him. If Mr. Hamada only wants to give me a 2-hour deposition and I get to reserve because we've got multiple other claims that he's not moving for summary judgments, this isn't cleaning up the case. It's just a rifle shot that Mr. Hamada wants to take now to put us in a position where he gets his summary judgment before we get our deposition.
Judge, I can, if you want me to address that, I can. I can address the issue of their production, which is, I would love to do. In fact, I'll do that right now, Judge. I mean, what I'm showing you here are all the disclaimers of reliance that Compass has made. It's in section 3.06. It's part of the exhibit that plaintiffs provided in their motion. But I'm telling you, they've disclaimed all reliance. In fact, what I just accidentally skipped over, not only did they say that they're a sophisticated party, but they said to the full satisfaction of the contributor, it has been afforded the opportunity to ask questions of representatives of the company concerning the terms and conditions of the transactions contemplated hereby. So let's talk about the production. They produced nearly 42,000 documents from—
Your Honor, I'm going to object. I mean, he's now arguing his summary judgment motion.
Well, this
The
is in my
question is-
response, Your Honor.
The question is,
My response.
I don't
And
know how what we've produced
Hey,
answers.
guys, this is what I'm going to do. I'm going to allow a 2-hour deposition. I'm going to set this for summary judgment in 6 weeks. And if there's a you guys work out the deposition, and for some reason you can't, make sure you're keeping track of your emails and things like that. If I feel like Mr. Lemoyne is, it's one side or the other's fault in terms of why the deposition hasn't taken place, then I'll look at that when it comes to whether or not to continue this again. But we're going to continue this one. How about, when is the summary judgment set now?
it is set, I think, for the 28th, Your Honor.
That's right, Your Honor.
Why don't we set it for, how about the the 19th? How does that sound?
Of July, Your Honor.
Can you look at your calendar?
Yeah, let me take a look.
Alex, can you grab Rhonda real quick?
That looks clear to me, Your Honor.
Mr. Lemoyne?
The 19th would work for the summary judgment. I would have, Mr. Ramada doesn't make us take the deposition during the 4th of July weekend, but I think.
You want to move it farther
Yeah,
out, I'll leave it up to Mr. Mata. I don't want to interfere with anyone's holidays.
Well, Your Honor, what's interesting is that we have a motion to compel set for the 25th of this month. And again, that's the issue, is like, we just don't have all of their documents. And so what I need to be assured of is that when we do this deposition, we're not going to be surprised with some documents that haven't been produced yet, or produced like the day of or a week before the depo. That's my main concern. And that's why we filed our motion for to compel. So, and this is a narrow issue. So one would think that the plaintiffs who have had these documents since 2017 would be able to produce them and say, look, these are the documents we're relying on to support our claim. We haven't gotten that.
Mr. Lemoyne, include this as part of the order. Any documents you want to use during this deposition need to be produced at least 7 days prior to the deposition taking place. So I'm going to continue this. Do you want to say the 19th, or when do you want to?
Yeah, Your Honor, that's fine. Shauna, Mr. Lemoyne and I can work at things out. We're friends.
Okay, so Mr. Lemoyne, this needs to be in the order. First off, put in the order that this hearing, this was ruled on today. So on June 6, 2021, the court made the following orders: that the deposition, what was the guy's name?
Mohammed Fotu, F-O-T-O-U-H.
Mohammed Fotu will need to be produced for deposition at least 14 days prior to the 19th. So I guess by July 15th or so. Sorry, July 5th. That at least 7 days prior to the hearing, Mr. Lemoyne, you will produce any documents you intend to use during that deposition, and that deposition will be 2 hours long. I think we're cutting it kind of close on all of this. You might want to move it a week or two back, but that's up to y'all.
Yeah, Judge, we'll talk, Mr. Hamada and I'll talk offline about that so we can pair up our vacation schedules.
Well, when do you want to set the hearing? I need to set the hearing now.
Summary judgment hearing, right? Is that right?
Yeah.
So you're saying you're offering the 19th, Your Honor, of July?
Yeah, but we could move it to the 26th or later.
Okay, well, we can move it to the 26th. John, will that be You think
Yeah, the
that-
26th will be better. That
Okay.
eases us up a little bit.
Give you a little more time. So this summary judgment hearing I'm sorry, you told me already a couple of times. What is it currently set for?
It's set for the 28th, I think.
So it's set for the 28th. We're moving it to the 26th of July at 3:00. Okay, guys, anything else?
No,
That's
you
it.
are. Thank you.
Thank you, guys. You be safe.
All right, bye-bye.
And get me an order on that, Mr. Lemoyne. Make sure you e-file and send it to Rhonda.
I will. Thank you, Judge.
Guys. Okay. The next hearing is on Macias. Is everyone here on that case?
I believe so, Your Honor.
Okay, let's go ahead and go on the record on cause number DC 19-16772, Macias versus C&W Construction. Council, make your appearances.
Eric Beck for plaintiff.
And Your Honor, Todd Wright for defendant C.W. Young Construction and Cipriano Hernandez.
Let's go ahead and proceed on the motion. Motion quash.
Your Honor, this should be pretty quick. We filed a motion to quash DWQs to plaintiffs' medical providers. Defendants filed a response and withdrew a couple DWQs that we were concerned about. And defendants have filed an order that should be ready for you to sign. So that's all I've got. I mean, they've withdrew a couple of DWQs asking for some documents that we were objecting to, but now they've withdrawn those.
Response?
Your Honor, Mr. Barrett has correctly stated the posture of this particular motion, and there is an order pending before the court, and Mr. Beck appears to be in agreement with the form of that order.
Let me make sure I have the right order that you want me to sign. Is that the order? Was that ordered? Is it titled the order denying motion to quash depositions by written questions to Foundation, Physicians Group, and MEG Healthcare and Protective Order?
Yes, sir.
Okay, so that's,
Correct, Your Honor.
and that's agreed to, correct?
Yes, sir.
Okay. All right, anything else, guys?
Your Honor, we've got a trial date of June 15th. I was just gonna ask you what the status is of your trials currently.
There's a very good chance, let me see, when is this case? This is a 2019 case, is that right? There's a good chance that this will be set on, moved to June 23rd, but we can talk about it. But yeah, there's a good chance it'd be moved to June 23rd. I have a trial setting then.
Okay.
So, but we'll talk about that more, I guess, on the date of the trial setting.
Okay. Thank you.
Yeah, and of course that implicates, how quickly we can get these discovery responses subject of this motion, Your Honor.
Okay. Anything else, guys?
No, sir.
Thank you, guys.
Thank you, Your Honor.
All right, our next one is Sudbury, 10705, so 10,705 LLC versus DFW A1 Pallet. Anyone here on that case?
Yes, Your Honor. Kelly Walker for DFW A1 Pallet Inc., the defendant.
Okay. And who's here for the plaintiff?
Plaintiff's counsel is Janice Cohen.
I saw her on the Zoom. Miss Cohen, are you there? Oh, she's disconnected. So guys, I just learned that the trial is going forward tomorrow. So just FYI. Yay.
Are you having a jury trial, Your Honor, or are you conducting a bench
It
trial?
looks like it. Yeah, it was supposed to be not until July 23rd. And anyway, long story short, I ended up, it looks like I'll have a trial tomorrow as well. So we're ready to try cases.
That's fantastic.
I don't know what's going on with Ms. Cohen, though. Alexa, how's your foot doing?
It's good. I'm waiting. I'm waiting on the doctor to come back in right now and kind of give me an update. They just did extra x-rays.
How did you break your foot? Your
I was
ankle?
walking. I was walking and I fell into a pothole, kind of,
Hmm,
and I rolled it. Yeah, and I heard it snap. Not
yikes.
fun. Yeah.
I've always been afraid of that. I've had that happen to me. Where I've rolled my ankle quite a few times, but I've never actually broken it. So that sucks.
Yeah, I don't recommend it. It's not fun.
Genesis, how are you doing?
Hi, I'm doing good. My AirPod died right when you talked.
Okay. Well, Genesis, let me do this. I'm going to take you to, I need to give you some quick information. Oh, there's Ms. Cohen. Remind me, I need to chat with you real quick.
Okay,
But
yeah.
Ms. Cohen, are you there? Ms. Cohen, are you there? Ms. Cohen, are you there? Ms. Cohen, can you hear us? Can you type in the chat if you can hear us? Ms. Cohen, are you there? Ms. Cohen, are you there? Ms. Cohen, are you, okay, I don't know what to do here.
Your Honor, would it work if we, could you call her from your bench and put her on speakerphone if Zoom doesn't work?
Yeah, I don't know.
I can give you her phone number.
I guess so. Ms. Cohen, if you can hear us, we're going to call you from my bench. What is your cell phone number?
Her office number, Your Honor, I have is 214-528-7977.
Okay, let me try.
Attorney's office, this is Jan.
Ms. Cohen, this is Judge Hoffman.
Yes, Judge, I was under the computer trying to get the camera turned on, and I don't know what the problem is. I am so sorry.
That's okay. Can you turn the sound on at least, or?
The sound was on, but then it doesn't come through, and I've got my computer tech on the other line trying to help me on, because I could hear all the previous hearings, and then when I go to get the sound, nothing happens.
Ms. Walker, can you hear Ms. Cohen okay?
Yes, Your Honor, I can.
All right, we'll just handle it this way. It's technology.
Right, Judge, I apologize, Kelly. I apologize.
That's okay.
I'm a dinosaur.
That's okay. That's, it is what it is. We just got to do our best is what we're trying to all do. So let's go on the record on cause number. This is a motion to compel, correct?
That is correct, Your Honor. It's plaintiff's motion to compel and defendant's motion for continuance.
Okay, so let's go on the record on cause number DC 19-20207, Sudbury 10705 LLC. Counsel, make your appearance.
Yes, Your Honor. My name is Janice Eve Cohen. I represent the plaintiff in this matter, Sudbury.
Kelly C. Walker, representing the defendant, DFW A1 Pallet, Inc.
Okay, so I think we're here on a motion to compel mediation. Is that correct?
That is correct, Your Honor. Plaintiff filed this motion to compel mediation in that the defendant had indicated, and I think there's a disagreement between Ms. Walker and I say that the defendant won't participate in mediation. The defendant's position is we will participate in mediation, but we need a continuance in order to do more discovery. Your Honor, back on September 18th of 2020, this court entered its mediation order requiring the parties to mediate no later than 30 days to its July 6th trial date. Subsequent to the entrance of that order, defendant's former counsel stated that once he deposed my client's representative or the representative or witness, Jill Free, that he would attend mediation. Mr. Martins then was substituted in as counsel of record back in March 3rd. I was notified there'd be new counsel. And we've been unable to schedule mediation because the defendant wants to conduct more discovery. And so I might be leading into the defendant's motion for continuance, Your Honor, but it's our position that this is the defendant's third counsel. Prior to filing the suit, the defendant was represented by Steve Koch at Glassman Phillips. We previously mediated this case back in 2018 or 19 as a part of a global mediation between Ms. Free and Mr. Free, the deceased president of the defendant. Subsequent to Mr. Free's passing, the defendant fired Steve Koch and then hired Dan Martins as the attorney. After Mr. Martins made an appearance, I got a phone call from defendant's counsel on about March 3rd that her firm now would be representing the defendant. On or about March 4th, I forwarded to her a copy of the amended scheduling order. Your Honor, it's our position that there's no valid reason for the motion for continuance based solely upon the necessity to conduct discovery. On March 3rd, I received an email from the defendant that they were substituting in as counsel of record. However, the motion itself was not filed for approximately 3 weeks later. It wasn't until the 30 days prior to the discovery deadline cutoff did the defendant engage in any form of discovery against the plaintiff and sent requests for disclosures. Now, the gravamen of the defendant's complaint is that we have all these issues that we need to explore, including but not limited to the possibility of a counterclaim. Well, that argument lacks any merit because the time frame in which to file a motion for a counterclaim has expired. The defendant then says, well, we need to depose all of these witnesses. Two of the witnesses are their former employees of the defendant. There is nothing in the defendant's motion for continuance that explains from the time I was noticed on March 3rd, 2021, until 30 days prior to the expiration of the discovery deadline, that the defendant has not engaged in any form of discovery other than requests for disclosures. As early as April 2017, I sent to defendant's first counsel, Steve Koch, a demand letter regarding breach of the parties' lease agreement and the estimates for the cost to repair the property. Those documents are the exact same documents that were attached to plaintiff's motion for entrance of default judgment, which the defendant has acknowledged it received. The only reason the defendant seeks the continuance is based upon this alleged disconnect between defendant's representative and its former counsel, Dan Martins. There is nothing to explain why the defendant has not actively engaged in any discovery. Now, the defendant seems to think that the continuance should be granted because plaintiff has not engaged in any discovery. I have deposed Tammy Sherman-Free, the representative of the defendant. That was scheduled to have occurred in early January, but because of my unforeseen hospitalization, the deposition was canceled. Mr. Martins then gave me new dates, and I sent the deposition notice. When Ms. Walker contacted me, she asked me if we could reschedule the deposition because she just got in the case. So as a matter of professional courtesy, I continued the deposition. But at that time, I expressed to Ms. Walker my concern about the deadlines imposed by the scheduling order were rapidly approaching, and nothing was done except sending a request for disclosures. So it's our opinion, Your Honor, the motion for continuance is baseless. This is a third counsel the defendant has had in this matter. The motion for continuance does not explain why new counsel has done nothing other than send the most basic of discovery on what was the timeline imposed by the amended scheduling order. And pursuant to the court's mediation order, Your Honor, it says that failure or refusal to attend mediation may result in the imposition of sanctions. Accordingly, Your Honor, we're asking the court to award plaintiff its reasonable and necessary attorney fees and the sum of $900 to present this motion. Thank you.
Response?
Yes, Your Honor, thank you. As somewhat of a backstory, Ms. Cohen represents to the court that this case was supposedly mediated and there was discussions with Mr. Koch, the defendant's first counsel. Well, in explanation of that, Your Honor, at that time, the owner of DFW A1 Pallet, Steve Free, was in litigation with his ex-wife, the owner of Sudbury 10705. So within the divorce confines of the case, they tried to negotiate some of these issues. A lawsuit styled in this manner on these issues was not filed in any court until November 29th of 2019. Mr. Free, the principal owner of DFW A1 Pallet, the defendant, died November 19th of 2019. The previous counsel, Mr. Koch, I have no explanation of how he handled any of the family issues on the divorce decree or how this was involved, but it was not filed until November of 2019. At that point in time, Ms. Cohen filed a documentation to seek a default judgment against the defendant for failing to answer. The court entered that default judgment on May 31st. On June 11th of 2020 is the first time that the defendant, now the owner of the defense company, is now the widow of the decedent. So this is the first time in June 11th of 2020 that the defendant received notification of the lawsuit. The court then entered its motion, its order to set aside the default judgment on August the 3rd, 2020. The court entered its schedule order, like Ms. Cohen said, at the end of last year, and I filed a motion to substitute in March. As to why Dan Martin's previous counsel for the defendant made certain representations that he was going to mediate a $350,000 case after he took a deposition, I can't speak to, and I do not want to appear before the court and be critical of other attorneys that are practicing before it. But what I can tell you is, since I entered the case, I filed the first answer in this lawsuit. Mr. Martins, when he was counsel, took a 1 hour and 6 minute deposition of the plaintiff individually, Your Honor. He did not send a corporate notice under 199.2. So what he did was basically take a fact witness deposition and he should have taken a 199.2 B2 deposition or B1 deposition of a corporate representative. So I can't explain to you why Mr. Martins practiced in the manner that he did, but I can explain that the defendant chose to have him replaced as counsel in a variety of litigation, including the estate of Stephen Free. since we have, Stobbs and Randall has become counsel, I have answered disclosures with which Mr. Martin had failed to do, which was for previously served. I have presented my client, who was noticed in her individual capacity, not as a corporate representative. And I have responded and amended my disclosures and also served a request for disclosure. The motion to compel, just as the motion to compel mediation, is completely inappropriate to the extent that this court would be compelling the defendant to mediate a $350,000 case when the defendant has 5 pieces of paper regarding the plaintiff's damages. And I can't discuss or represent what the decedent who owned this company did or did not do back in 2017, but that's irrelevant to the matters before this court. Since this was filed in November of 2019, and then by June of 2020 was the first time the defendant received notice. So the fact that Mr. Martin's, the previous counsel, did not serve any discovery, he did not serve any interrogatories, he did not serve any request for production, and he did not depose necessary parties, including a proper corporate rep deposition notice of the plaintiff entity. Pursuant to 252, Your Honor, of the Texas Rules of Civil Procedure, the motion provided to the court on the continuance filed on May 25th specifically outlines the discovery to be conducted on the 4th page of that motion. And it identifies, as I pointed out, interrogatories to serve on the plaintiff in production and to depose the corporate representative. When I received the plaintiff's disclosures, which were just several weeks ago, was the first time that they were, I'm sorry, Your Honor, it was May the 7th, I received plaintiff's responses to my request for disclosure in which they designated experts. We've had no opportunity to depose those experts and are in a current position where there must be depositions of people identified by the plaintiff in their disclosures taken prior to trial. The fact that there is material discovery to conduct and there is an explanation as to why I am before you, because I have not been counsel except for the last two and a half months. I have participated in discovery. Previous counsel agreed, as Ms. Cohen pointed out, he would mediate a $350,000 commercial lease breach case and never did anything about it and never answered the lawsuit. So to force the defendant to mediate a case, it's going to be unsuccessful, even though we certainly would try to mediate in good faith. We have no basis to respond to that. And in my
all right, wait. So let's kind of talk this through. What discovery still needs to happen at this point?
Your Honor, we identified on behalf of the defendant in our motion under 252 that we needed to conduct written discovery in the form of interrogatories and production.
Written discovery you could have sent a long time ago, right?
Well, Your Honor, our substitution was granted, so I didn't have any authority to do that till the end of March. So right. Yes, there was an opportunity that I could have filed
we're not continuing on that basis. What else is there?
There's the deposition of the corporate representative, a notice of which has never been sent under the rule 199.2.
Okay. And have you attempted to take a deposition, a corporate rep deposition?
The deposition that I did not even have a copy of, the file, was provided by Ms. Cohen, and it was taken of a fact witness. I have not had the opportunity to prepare
have you attempted to take the deposition? Have you sent notices or requests for dates, or kind of what's your?
No, Your Honor. And unfortunately, the past 60 days have been filled with the variety of different cases that we've substituted in, and that's no excuse. I understand that we had 60 days to conduct discovery, but if I send Ducis Tecum with my subpoena, even to a party, they get 30 days to respond. And I was not able to promptly get in the opportunity to prepare that before. And there's also fact witnesses that were identified on May the 7th in plaintiff's responses to requests for disclosure, which also included the designation of an expert. And I have filed this motion for continuance on the 25th, which was about 2 weeks after I received her disclosures. And I discussed with Ms. Cohen that, there is some foundational discovery that needs to be conducted, given the fact that previous counsel.
How many fact witnesses do you need to depose?
Your Honor, I have 1, 2, 3, 4, 5. I have 5 fact witnesses, the plaintiff's expert, and then the corporate representative. And I believe
And those witnesses were not disclosed until May of this year or May of last year?
May of this year. And Ms. Cohen is correct. 2 of the people she disclosed are previous witnesses or previous employees. However, the decedent who employed them is no longer around to be able to provide sufficient information or to reach out to them. So my client, who's the widow, has taken over this business and did not have authority to even do so until February of this year, when she was appointed executor of her husband's estate. February of 2020. Sorry, Your Honor.
Ms. Cohen, there's 5 fact witnesses she's talking about. When were those first disclosed?
Your Honor, they were first disclosed when the defendant sent us the request for disclosures. That's our main objection, Your Honor. The defendant represented on March 3rd, the firm had been retained. The motion to substitute counsel wasn't even filed until nearly 3 weeks later. During that 3 weeks, they could have sent the request for disclosures. I specifically spoke with Ms. Walker about the concern that deadlines were coming up, and that's why I sent her a copy of the amended scheduling order.
Ms. Cohen, let me just ask this. When exactly did they first send these disclosures to you?
They were sent 30 days before the deadline for the discovery cutoff. They were sent April 7th, and the responses were due on May 6th. I disclosed my experts pursuant to the court scheduling order on or about April 26th. Now, the defendant contends that the discovery cutoff is actually June 7th. I never received any interrogatories after I sent the request for disclosure responses. There was time, if we go by the defendant's deadline, if it's June 7th. I received no phone calls asking for depositions. Nothing was done.
Respectfully, Your Honor, I presented my client for deposition as Ms. Cohen represented, and she and I have been in communication. It isn't a situation where I have been out of pocket. We have exchanged correspondence with the mediator. I have explained what discovery we need to conduct. And essentially there was, once the order was filed for us to substitute in on March the 30th, we filed the motion for continuance in May, and to get the file from previous counsel and meet with our client. We've had less than 60 days to obtain a file, figure out that nothing was done on the file, and that's a disservice to the defendant. We've also requested a jury demand in our amended answer that we filed. I'm sorry, Your Honor, filed a separate jury demand on May the 12th. So, we have filed an answer, we have filed a jury demand, we have filed a request for disclosure, we've presented our client for deposition. We have exchanged communications with Ms. Cohen and the mediator regarding mediation. I have not been dormant or not involved. And I think, there has been several things that have occurred in the last 60 days related to this matter.
Your Honor, when counsel contacted me about substituting in, I discussed with her that deadlines were rapidly approaching, and I sent her a copy of the scheduling order. Ms. Bree is the corporate representative for Sudbury, so we're kind of exchanging terms here, deposing her as a fact witness. She is the representative of the company. She was asked questions about the lease. We have pursued our case in the manner in which I think it's appropriate. As indicated, this case was mediated way back in 2018. I'm familiar with the facts, so what I attempted to do has no bearing on the discovery to be conducted by the defendant. And as indicated, 3 weeks passed before the defendant filed a motion for substitution of counsel.
Okay. I know, I get it now. All right, so this is what we're gonna do. I'm gonna reset this to September to give you a little bit of time to do discovery, limited discovery. How does September 7th, 14th, 21st, or 28th sound?
14th, Your Honor.
Your Honor, we would request the 21st.
Does that work for you, Ms. Cohen?
That's fine, Your Honor.
All right, we're going to reset this to September 21st. We're going to allow there to be a new corporate rep deposition that will be up to 3 hours long. And we'll allow 10 ducus tecum attached that need to be set at least 30 days in advance. For these 5 fact witnesses, I'm going to let you take 2 fact witnesses for up to 2 hours apiece. And you need to disclose right now, Ms. Walker, which 2 you want to take.
Your Honor, Tenant Leroy Jordan.
Okay.
And my question, I'm not trying to dodge my answer, but I need to depose her expert, and I believe her expert relied on certain of the fact witnesses I'd like to depose. So if her expert could be made available, then I believe that would reduce the.
All right, we're gonna order. She has 1 expert
On her damages, yes.
I'm sorry.
Your Honor, she had our expert designation prior to the disclosures being due. She's been on notice of who our expert was and did not ever ask to take his deposition. And this motion for continuance was filed after I filed the motion to compel mediation.
I'm gonna roll on the motion to compel mediation. So the expert is going to, what's the expert's name?
His name is William Jones, Your Honor.
Killian Jones, okay.
William, as in Bill.
Oh, William, I'm sorry, I thought you said Killian. William
Yes,
Jones will need to be produced. And then for deposition after the mediation. The mediation will need to take place within 1 week after the first. So there'll be 2 rounds of discovery. There's going to be taking the corporate rep deposition and the 2 fact witnesses. Then we're going to do mediation, and then we're going to have the expert deposition, and then we're going to have trial. Does that make sense?
Yes, Your Honor. And my concern is that the expert witness is opining, as I put in my pleadings before the court, that for instance, a 10,000 building is required $190,000 for that. I have no documentation to be able to mediate those damages if I do not take.
I'll leave that up to
Ms.
Ms. Cohen. If she wants to produce the expert before the mediation, she can. If she wants to produce it after the mediation, she can. It's her choice. And understand that I could also order that no discovery take place. So I'm giving you kind of a break, Ms. Walker.
I appreciate your understanding.
So Ms. Walker, I need you to prepare an order. The order needs to say that this occurred on June 7th, 2021. This hearing took place, and that you got down all the stuff that I said, that you can take 2 fact witnesses, 1 for 2 hours apiece, the corporate rep for 3 hours with 10 ducus tecum. The mediation's then going to take place after round 1 of discovery, and then the expert will take place, deposition will take place either before or after the mediation at the discretion of Ms. Cohen.
Thank you, Your Honor. I appreciate your time today.
Go ahead and email that order to Ms. Cohen, and then once you guys reach an agreement as the form of the order, go ahead and e-file it and email it to my court coordinator, Rhonda. Make sure it does include the date on there, preferably the signature of both parties.
Yes, Your Honor.
All right, guys.
Thank
any
you very
questions?
much. No, Your
Honor,
Honor.
as far as the other deadlines imposed by the scheduling order.
Nothing else has changed.
About the experts and our pretrial materials.
Everything else is the same.
Okay, Judge. Thank you.
Does Your Honor, the expert discovery deadline for the defendant, or do we have an opportunity to engage one?
Is your deadline passed?
The deadline is passed, Your Your Honor, and
Your
she
dead-
had my information.
Your deadline is passed. Okay?
Yes, Your Honor, I understand.
All right. Thank you, guys.
Thank
Good to
you.
see you.
Thank you, Judge, and I apologize for the camera snafu.
No problem.
Thank
You be
you.
safe, okay?
Thank you.
Thank you,
Thank you so
Judge.
much. Bye-bye. Okay, let's get to our pretrial docket. Have some good news. We were not supposed to go quite this quick. I thought we might go on Friday, but we've learned that the primary judge who was supposed to go tomorrow is unable to go forward, and the backup judge. And so they've given us, the 68th, a trial setting for tomorrow. So I see these trial settings kind of like a pot of gold at the end of the rainbow. We get to try a case tomorrow, guys. Are you guys excited as I am? All right, Mr. Lohr, you look excited. Mr. Easton, are you excited? Come on,
Always,
guys.
Judge. Always, Judge.
All right, Mr. Suberman, are you excited?
Judge, I can barely stand myself. I'm so excited. And,
I know Mr. Scott's going to be excited. Mr. Jenkins, no one is as fearless as Mr. Jenkins is about trying cases. So
I was there this morning and I was number 3 and I almost got to watch it. It's a good day to be moving forward.
that's great. That's great. So we just need to figure out an order and kind of who's going to. I think at least one of these cases, the parties have agreed to a 6-person jury, so that case would be first. Warren versus Lloyd, I agreed you guys would be number 4, unless something has changed, and you guys have agreed to a 6-person jury, right?
Correct, Your Honor.
Okay. All right. Jennings versus Gonzalez. Is anyone here? Are you guys both here?
Plaintiff's here, Your Honor.
And Your Honor, this is Young Jenkins. I'm appearing on behalf of Alfred Blue, who's left our office, so I'm here as well.
And did you guys agree to a 6-person jury or no?
No, we did not.
No 6. Okay, so you're a 12-person. Okay. Can you agree now or no?
No, Your Honor.
Okay. Signs versus Backer.
plaintiff is ready, Your Honor, and I agree to a 6-person jury.
Mr. Scott. Where's Mr. Scott?
He's
I saw
here.
him.
Okay, he's on mute.
Mr. Scott, you need to unmute.
You're still on mute.
Sorry, Judge. 12 jurors, please.
Okay. All right. And then finally, Almazan versus Aguanaga. Are both sides here? Mr. Stillwell? Okay. How about Miss Mann?
Yeah,
Is any-
John Stillwell here. Am I on that case?
I don't know. You're not listed.
No, I didn't think so. I'm on a different case, just
Are you here for a pretrial or for something else?
for a hearing that actually Ms. Chandler's motion.
Okay. Who's here on Almazan versus Aguanaga? Tanika Mann and Cass Karamidas? Is there anyone else here? Mr. Lohr, what are you here for?
I'm here with Mr. Stillwell and Ms. Chandler on the motion for reconsideration or protective order. It's Ms. Chandler's hearing.
Okay. So you're not here on the pretrial docket then, is that right?
No, still excited to get back trying cases out.
Okay, well, I'm glad you showed some enthusiasm. Let me look at this real quick. Let me find out what's going on with that other case. Maybe they've settled. So you guys are on Jones versus Johnson, is that right?
Yes, Your Honor.
Yes, Your Honor.
Okay. All right. So let's talk about Jennings v. Gonzalez. Are you guys both ready to go to trial?
Well, we've been ready, but they had filed a motion for continuance because Mr. Blue had left the firm, and I did not oppose that motion. But also, Your Honor, we were getting called down from the 101st for tomorrow morning. Did that ever get worked out, or?
I don't know. This is the story that I've heard, is that the local administrative district judge contacted me and said that the number one judge said, no, he can't go. The number two judge, which is the 101st, said, I wasn't sure. And I was told that we were supposed to go forward. So what have you been told?
That it was still up with the administrative judge to sort it out. But they were pretty adamant that tomorrow was their day, but you had contacted us
think
Friday. So
let me do this. I'm going to go on.